Yes, welcome back to the No State Project for this Wednesday edition. Of course, live from the fortified compound in Mesa, Arizona. Glad to be with everyone today. As y'all, I've been out here a little too long, I guess, but everyone starts to file in, and I'm almost better. I know I was a lot sicker last time, but I think I kind of got my voice back, and I started coughing already. But we'll see how the rest of the show goes. I did put in the show notes. I remembered that, so I'm off to a better start than last time. The new call-in number, which is, and I'll give this out a few times during the show, of course, as people start to file in here. It says 717-275-8941. 717-275-8941. I guess I could be more professional. Oh, yeah, so you can actually see that. But I guess if I can get it out of view, 717-275-8941. And the passcode is 1233428. You can always get me on Skype at Frank Rizzo 3. And I just ask that you instant message me first so that we maintain some level of professionalism. Yes. Aloha, mahalo, our friends in Hawaii listening. Glad you guys could tune in. Appreciate you guys taking your time to watch an online broadcast right here at my YouTube channel, No Stay Project. If you want to help support the show, it is much appreciated. It is markstevens.net and markstevens.cells.com. Maybe I'll start using the OBS again, and I can start just doing graphics as I do the live broadcast, but we'll see how that works out. What sucks is that the new caller line, which seems to work pretty good, not really so much on. I haven't figured out how to use it on Linux yet because it only works on Google Chrome. So yeah, I don't know about that, but what can you do? I don't know why anyone would design it just to work on one particular browser, but at least they didn't design it to just work with Explorer, because then I'd have I think I'd have a problem. What can you do there? But again, if you want to join the show, it is now 717-275-8941, and the passcode is 1233428. So if you guys want to copy and paste and put that into that there the chat, I'd appreciate that. And hey, if you're being attacked by a bureaucrat, I'm going to talk about that, of course, today. Because, wow, if you look at the tentative title to the show, another brazen admission from an IRS agent today. And, wow, we'll get to that. But if you are being attacked by a bureaucrat, you want to learn how to more effectively defend yourself, to be able to tear apart an argument, basically to question somebody who's making a claim and expose that either by their admission or their lack of being able to support the argument with any facts or logic, then markstevens.net. And so what I did, of course, today, I've been on the phone a lot this week with the IRS. And last week on the Saturday show, I was able to happily report that we got 2 stays. So that's what I talk about, getting a stay of the computer process. And somebody emailed me and said, why? I can't stand using Windows. I've got 200 gigs worth of space on this petition, and I lost part of my damn recording the last few minutes because it said that I was out of disk space. So this recording is, even if it's as a WAV file, it's not going to take 200 gigs. It's uncompressed, but, still. So anyway, why is it so important to get the stay? Because you got to stop the process. The more it escalates, anybody could tell you the more an IRS or a bureaucratic situation escalates, the worse it is for you to try to get it resolved. It's just that it's that simple. So typically what happens once we get that stay, you know how the IRS works, they don't acknowledge much. So as long as the computer process has been stopped, let them take as long as they want, ignoring our paperwork. As long as it doesn't escalate, we don't care. So I was not able to get a stay yet this week. So it would be pretty rare to get 3 stays within a 1 week time frame. But I am working on it. And so what I tentatively call the show, I'll probably keep it that way. Has it ever been that I changed the title of the show after I've did the live broadcast, maybe a word or two? Someone saying, can you talk about ratification of the 16th Amendment, Bill Benson's research and findings in his law that never was? Oggi domando, I don't remember how to say sometime in Italian. I have a real disagreement with the whole process that someone like that uses to try to make a case that the 16th Amendment wasn't formally ratified. I don't even look necessarily directly at. I actually had to mention the 16th Amendment today because they tried to say something about the Constitution, but that's your argument. You know, when we're talking about the IRS, it's not like a traffic ticket where they may not explicitly say the Constitution. They do with the IRS. They was their entire basis is the Constitution, not a particular statute, usually, but it's the Constitution, the 16th Amendment. I don't like to get into stuff like that because it puts a burden on me to actually prove that that's true. And I've never seen anybody have any success whatsoever against the IRS by arguing Bill Benson's work that it just was never formally ratified. I think that's I just don't think it's a very good argument. So anyway, getting back to what I was talking about with this call with the IRS, I've heard this before. I did have an agent Marconi come out and say, we don't need evidence. I don't have any evidence and I don't need any evidence. But that was a couple of years ago. I had an agent today, and that was a supervisor. I actually had a direct number, and I spoke to the supervisor. Actually, it was the supervisor that added to it that we don't have any evidence and we don't need any evidence. So with this agent today, I walked her through the process. Now, mind you, if you're new to this, we're always trying to deal with the claim that the agent attacking you or the department that's attacking you, we want to make sure that we have their claim right. And so she had already agreed that their premise, their operating presumption was you earned money while in New York. That means the laws apply and there's an obligation to file a return. That they already agreed to that. That was the foundational claim. She even tried to, this is what something, I had, one of the questions was, so your position is, because they said about some tax information, a tax report, like a 1099 or a W-4, or W-2 rather. And so I have to ask a clarifying question. So your position is that the compulsory report of income, of money, in this case, let's say 1099, the compulsory report of money somehow proves your Constitution, a written instrument, applies and gives jurisdiction and creates this alleged obligation. I just lost my damn podcast recording. I'm going to have to pull that off of this feed, this live feed, which I don't like to do, but I don't have a choice right now. So it's not going to work too well on Windows. Gee, there's a shock. A problem with Windows. What a crappy operating system. No, it's not garbage in, garbage out. That's all because of me. That the problem is between the keyboard and the monitor. Or however that phrase goes. JT would knows what that is. So I'm going to be a little delayed on my on the podcast at markstevens.net. Anyway, she actually takes issue with, what do you mean compulsory? Well, the 1099. That's compulsory. I don't agree that it's compulsory. And I said, oh, okay, well, let's look at the facts. People file it under penalty of prosecution. If the company was not to provide the 1099, they could be prosecuted, right? Well, that would make it mandatory, but I don't think compulsory. I expect that kind of hair splitting garbage from lawyers. I don't know. Maybe she had some legal training. But I said, isn't mandatory and compulsory the same damn thing? You have no choice. You do it or you are punished. Yeah. Now mandatory and compulsory are not the same thing. Well, maybe you got to go to law school to know the distinction. But to me, they're synonyms. They're the same damn thing. You have to do X or they will do Y to punish you. Right? Mandatory, compulsory, required. It's all the same thing. All the same damn thing. But she doesn't want to answer my question. And I'm saying, well, what facts do you have that the compulsory report of income actually proves the Constitution applies and creates these alleged obligations? No, it's not a surprise. She don't want to answer those questions. They never do, because you cannot prove that that forcing a company to create a report of money transferred proves that the laws apply. It's not, it just, you have to assume that the laws apply in the first place and then see if that action falls within that statutory language. Government's not slavery. Government is a slave institution. It is a criminal organization that create, that forces us to work for them. So she actually says to me, again, it's not the first time, but it was pretty brazen today. And she was not backing down. She said, the IRS doesn't have to prove anything. Sir, we don't have to prove anything. You have to prove. I said, you do understand, or maybe you don't, that even according to your Supreme Court for 200 years or more, that whether it's the IRS or another agency, unless your foundational claims are based on facts and not assumptions, then no presumption of correctness is created. And if no presumption of correction is presumption of correctness is created, then no burden shifts to me or my client. She didn't want to accept that. I said, well, okay, I'm used to the IRS not following the law, because we had already established once again that the Internal Revenue Service, even though this woman was claiming to be going by the law, did not want to comply with Section 3705 of the Restructuring and Reform Act of 1998, where the IRS, after a summer or so of hearings where people could hear firsthand about abuse by these IRS agents, passed the, this massive Restructuring Act and Reform Act. And I would say out of 100 requests for an agent to be assigned, maybe one time out of the 100 have they ever done that. They told me in Buffalo it was a policy not to comply with that. So, this idea that the IRS follows the law, even as interpreted by the Supreme Court or the lower courts, not true. Absolutely false. No, to have a presumption of correctness that would then shift the burden to the victim, or let's say the defendant. The foundational claims have to be based on facts. Otherwise, you have what is called a naked assessment. They're just making an assumption. So at one point, she says to me, well, if he lives and works in the United States and then he gets money, then he's got to pay. Well, that's an opinion. That's a legal opinion. No, that's a statement of fact. I said, you think that when you apply the law to a set of facts, or you make a determination that someone has a legal obligation, you think that's a statement of fact and not a legal opinion? Wow. So right there, you realize you're talking to somebody that they don't know the difference between a statement of fact and a legal claim. And And it's really difficult to try to get through to someone like that because they just don't understand. They just don't get it. And they probably aren't going to put any effort into, and say, we're not going to convince them otherwise. So I said to them, look, the report of income being forced or compulsory, that is a statement of fact. Now, whether that report of income or of money proves it's taxable income, that is a matter of legal opinion. That is a legal claim. That is not a statement of fact to say that it's taxable income. To say income is taxable, to say that someone is a taxpayer, to say that somebody is a resident is not a statement of fact. It is a legal opinion or a legal claim. It is absolutely 100% not a statement of fact. It may be based on facts and supposed to be based on fact. Yeah, but it is not a statement of fact to say that someone's a taxpayer. And that was another thing that she didn't understand either. Well, what's the issue? Because when you use the word taxpayer, it's not a statement of fact. It is a very loaded legal claim. It's a legal allegation in a sense. So until you have some facts to support your legal claim, don't say it. Say this woman, there was no getting through. She wasn't, but she was, the one thing we confirmed there, one of the two things we were able to do. One, she was not able to prove the IRS's claim in any shape or form. Couldn't prove it. But we were also able to have her confirm that the IRS has now, in this case also, okay, like all the other ones, now has a long-standing pattern of not complying with the Reform and Restructuring Act of 1998, because they will not even put the request for an agent into the system. So we spoke to an agent just yesterday. She told us that she put the request in. So what I like to do is if we have to call them again, confirm. Can you look in the computer right now? Do you see a request in there for an agent to be assigned? No, I don't. Okay, let's write that down. I said, we have enough. And I even had to say to her, you talk about wanting to comply with the law and be law abiding. Yet you just confirmed that your department has once again failed to comply with that section of the code. So I wanted her to put the request in. And she said, well, I'm going to have to research. What is there to research? I need to research if we can do that. You have to research are you going to research if that is a legal requirement that I'm citing the statutory authority correctly, or are you going to see if that is something that you can do in your department? So we wind up not getting a straight answer. That's what I use it, because depending on what may happen, if it does escalate, we have a solid statutory violation, because I know that's the whole thing for these people. Mark, can you show a statutory violation? Yes. We requested an agent to be assigned with direct contact information. They never did it. There's your statutory violation. How is that unfair? How does that change anything? Because we can't resolve it. We can't get to a single agent who will accept any responsibility whatsoever, because every single agent will try to kick the can to someone else. And the lawyers, if it gets that far, will say, well, what the hell are we supposed to do with Agent Powell, number 10035782? We don't even know where that, we can't even track down if that's a real agent or not. And then they can always say, oh, a call center. You can't have a call center employee buying the entire Internal Revenue Service. But if we have an agent with direct contact information who is actually taking responsibility for the legal claims that are being used against us, now we've got somebody, even though they lie about their name, we've got somebody that we have direct contact information for. We know what building he works in. So if we have to, even if we have to serve the pseudonym, we can track them down for service. And they're not able to then turn around and credibly say, well, they can't bind the agency. No, they're the ones, they are the face of the agency. They're the ones making these claims. So let me give the number out again. We'll start taking some calls in a few minutes. But we got, if you want to join the show, it's 717-275-8941. And the password is 123-3428. And you got that there. Skype, that is Frank Rizzo 3. That's the number 3. So just insta message me first. I'm going to do a video on this. I'll get to the call in just a second. I'm going to do a video on this. I know I'm starting to rack things up and things, things are, they're piling up. But just today, got another ticket tossed out in Bexar County, Texas. So big congratulations to Lestat there. Traffic, sure. Criminal, yeah. Tossed out. Filed a motion to dismiss. Was fighting it like a caged animal. And basically in that he's professionally and courteously holding the prosecution to their burden of proof. And that the motion to dismiss is based on the fact that the prosecution has not met even their prima facie burden. That they're arguing without evidence. And maybe like the IRS or Tiffany Castillo in Massachusetts there, arguing not only without evidence, but actually arguing they don't need evidence. Yeah. So, no, this is not a situation where the police officer didn't show up. That's not what happened. This is another case that the prosecution withdrew. And yes, the judge signed off on it. They are allowing me to post that unredacted. Now, I don't remember off the top of my head if his home address is on there. I'm going to redact that regardless. But I don't have to redact the case number. So it says right on there, and I'll do a separate video. Like I said, it says right on there, dismissed by the prosecutor. They filed a motion to dismiss. The prosecutor did, and said it was in the interest of justice. Maybe because they didn't have a shred of evidence to support their claim. Or maybe they had a shred and that wasn't enough to make a prima facie burden. To then shift the burden, to create a rebuttable presumption, which it did not and cannot. Just being physically in Texas is no evidence whatsoever their laws apply. Which is why no one can actually present any evidence. And the best that they can do, I'm not even going to quote the critics, because I don't give it, that it's meaningless to me. I'll go to someone who actually counts as far as their position. That the best that's ever been done, we had a federal magistrate say that the application of federal law was largely arbitrary, which is nice because he's actually a state actor. And then you have Scott Bales, who is the Chief Justice of the Arizona Supreme Court at the time. I don't think he is anymore. His position was not that it was a legal claim or a political claim that the courts can't hear. No, what he said, just like his fellow justice now, my gosh, Bill Montgomery on the Supreme Court. Gee, oh my gosh, at least Scott Bales was anyway. Bill Montgomery is now on the Supreme Court in Arizona. Both of these men said the same thing as far as evidence proving the Constitution applied to me, just because I'm physically in Arizona. Because they prosecuted and put other people in prison. That's the best they could do. Which, of course, is a non sequitur. It doesn't prove the proposition. Doesn't prove the proposition at all. And if anyone disagrees, 717-275-8941. The passcode is 123-3428. See, if I use OBS again, I can get that right there, and it'll be permanent. It'll be part of the broadcast, and I don't have to keep saying it. People can see it. They go, oh, that's the number I could call in, and I could tell this jackass. Yeah, I'll give you a dressing down, Mark Stevens. I'll prove to you this written instrument can apply just because they say so. I'm telling you. So far, no one's been able to do it. But you're welcome to call the show in order to give it a shot. I will get to the calls now. Whoa, hello. We've got area code 414. You're live on the No State Project. What's your name? Where you calling from?
Hey, Mark. It's Mark from Wisconsin.
Hey, welcome back to the show, Mark. It's been a long time.
Yes, it has. I've been able to avoid the cops in Wisconsin here for about 4 or 5 years.
Nice. So yes, unfortunately, you do have another episode.
Yep. So just a few things. I have a initial appearance date on February 12th, so I believe that's just like my plea date. So I get to go up there and tell them guilty or not guilty. But I wanted to have all the documents submitted before then. So when I'm sending these out, because again, it's been a long time, do I need to put anything specific on there? Or do I need to put like the attorney or, district attorney or anything, or?
What I like to do, just so there's less chance that they, that there's an issue where they don't get it or they can claim they didn't get it, which does happen occasionally. Yeah. I put on the envelope the case number. I may not, if I know the attorney's name that's assigned to it, I'll put the attorney's name and the case number. So that helps, I guess. I'm assuming that helps ensure that that it's going to get to the right guy.
Okay. And then also with the certificate of service, because on there you have that this is a true and correct copy that's been emailed, and that's the one that's usually going to the officer that pulled you over. Does that sheet need to be included with both the motion to dismiss and the discovery request?
The certificate of service is the last part of every pleading that we file in court. That has to be, so you'll notice there's one at the last part of the motion to dismiss has it, and the discovery request has it. Everything that we file in court to the clerk of the court has to have a certificate of service with it, showing that we are also sending copies to opposing counsel.
Okay. And so that'll be the one where we can, when we send the copies to the officers, we don't need to put in the certificate of service into his mail, right?
Well, the certificate of service, if we know for a fact that because it's minor traffic and there's not a prosecutor assigned and we're going to send it to the police officer, we have to put his name, badge number, and the address to the police department in the certificate of service, and we have to sign it.
Okay. All right. Yeah, luckily the place I'm at, the courthouse and the police station are the same thing, and the courtroom is actually where they have their town hall meetings. So,
any chance we're going to see video of you questioning the city council?
So I went in there, and they allow you to speak for 5 minutes, but you are not allowed to ask them any questions, and they will not answer any questions.
You gotta, yeah, Scottsdale does that. I mean, well, what is, all right. Well,
they don't want to be called out.
Well, it's true. You don't have to go to the particular city that it's in if you want to get some, get your feet wet and do some sparring with them. You can go to another one. But, even just if it's your first time, just getting up there and speaking for a few minutes in front of all those people, even if they don't answer, it's still, I think, good practice along the way. It's just something you can do. And, you should definitely get to a situation where other people are responding to you. Yeah. But especially for those who are new, just to get in there and to do that is going to make, when you walk into court, which is usually going to be smaller, there's not going to be nearly as many people depending on where you are, it's going to make it easier. And so whatever we can do to take some of this anxiety and the stress away from going in, and it's going to make it easier for us to then make the right objections and defend ourselves better.
Yeah, and I actually did stand up initially because I had said, because they said that I couldn't have a cover over my license plate. And you can still see my license plate. It's not blocking anything. So I even went up there and I said, the local auto store that's right, a block away sells this exact thing. So the fact that you guys are not even telling the store, hey, maybe you guys shouldn't be selling these, and they try to pull the, oh, well, we can't control what gets sold. And it's like,
They actually said that?
Yep.
They can't control what gets sold.
And everybody else,
marijuana or things like this. We get alcohol. No, we got no control over what is sold over here. What do you think? I'm 5 years old. You can say something so stupid. Holy crap! The city council. Wow. Okay.
Yeah, and the people that were in there, when I told them and I showed them what I had, because I brought it with me, even everybody else that was in there were like, I don't get how they could give you a ticket for this. Like, this shouldn't be illegal. So even the people that were there were kind of like, that is retarded that you got a ticket for that.
It is. It just reminds me, because in Scottsdale here in Arizona, they were super aggressive with the photo radar stuff. And they were, so if you were to go back, you could still see pictures if you were to go back 15 to 18 years ago, because cops would stop people, not to give them a ticket. They would stop them and they would remove whatever covers were on the license plate. Now, because the law, the sacred writ, says that it just has to be visible from a certain distance, what somebody did was make a louver. And so when you were straight behind the car, you had a louver. So, like blinds. And so if you were straight behind the car, as the law required your visibility, straight behind, you could read the license plate, no problem at all. But boy, if you went at an angle, you couldn't read a damn thing. So the cameras couldn't get a picture. And then some of them, depending on what the material was made of, it was purposely done so that when the light hit it, you couldn't read it anymore, which was the purpose of putting them on. So they used to actually stop people and take them off. In fact, they actually started stopping people because this was reported in all the local news. It was hilarious. I thought it was great. People started going down certain sections of the street in Scottsdale with masks on. So they would get a picture taken of them, but they're so furries were in their heyday at that time.
Yeah.
So people put a Batman mask or so on. And so that they could defeat the ticket that way. So, wow.
Yeah. The officer told me that he had to be able to see the license plate from 100 feet away at 1 a.m. in the morning. And I'm like, really?
100 feet away?
I even asked the chief of police was at the town hall meeting, and I had even asked them, I said, so where does it say it has to be 100 feet away that you have to be able to see from? And he's like, well, there's not a dedicated foot distance that we have to be able to see. He was all shady with the question. I think he realized that the cop asked a lot of stupid questions or made a lot of stupid statements. And I was probably the first one to actually go into the city hall and actually kind of complain to everybody else and not just go in and talk to him. So he kind of got put on the fire there.
Yeah, I think on this, if you're not able to get it tossed out on the lack of evidence showing jurisdiction, subject matter and personal, I think on the merits alone, you probably get the thing an acquittal.
Yeah, that's what I'm hoping for. And, I'll be able to go. They have Wednesday nights is when they have the either like all the court dates. So actually, after I get off the phone with you, they have trials going on tonight. So I'm going to be driving over there just to sit and observe and see how they do it, see how the judge is, just so I can kind of prepare to know if he's a person that has any kind of ethics and is willing to, make the prosecutor have, stay to their burden. So
be nice.
But,
that's all.
Like you said, just going in there to get used to it and get kind of like all the other pre-jitters out.
And if you do take the opportunity, if you have that opportunity to speak for a few minutes in front of the city council, damn it, Yeah, send us a link so we can see the video.
Okay. Yeah, I'll try and get a video so I can do that. Yeah, it's always more fun in these small town ones because they don't really want to do a whole lot of talking when you start to ask them questions like that. So
yeah, see, but I lucked out. I lucked out in Tempe because there was a lawyer on the council, and he liked to talk. He came on the show. He tried to say that anarchist, we had our shot during the Civil War and we lost. I was bewildered why he would say that the Confederacy were anarchists. I couldn't. But that was the best that he could do. But he did give us the gem. We have jurisdiction because we said so. Like, okay, yeah, that's good. Hey, the video I did in Scottsdale, still a lot of people noticed it, and it's one of the higher viewed videos that I have, and other people have mirrored it. So even if they're not responding, it's good practice for us, and it is good for other people to see that, so that because at least they're entertaining the question themselves. So. I forgot to turn the notifications off, so I'm getting a line of calls. So I'm going to have to let you go. How did I forget?
No, that's fine. Yeah, I just want to call quick and just ask a few questions. And just a reminder that I've seen other roleplay videos posted on YouTube that have been good to listen to, because some of the guys on there really go all the way, so to make it as realistic as possible. So people should look for those also on YouTube. Yeah,
I need to start doing that again, and we're going to be working on that. But I appreciate the call, and let me know if you're going to go to a city council, so I can send you some questions.
All right, yeah, we'll do.
All right, appreciate the call, Mark in Wisconsin, where I know I have family in Idaho that got buried, but what really got hit hard was. Like I've mentioned before, I do have family. Part of my family did come from Newfoundland by way of Ireland, of course, the Moriartys. And if you're a Moriarty from the Irish Loop, the Avalon Peninsula there in Newfoundland, then we're family. And they got buried. I mean, I'm seeing pictures that cousins are sending me, and they got buried. It's worse than New York or even Buffalo in 1978. I mean, it is bad. You're talking 6-7 feet with drifts. Oh, it's just, of course, it's 72 degrees in Mesa. I'm not, but yeah, it's quite something. So anyway, we'll go to as far as I know, everybody is a new caller with this new system. But we got area code 618. You're live on the No State Project. What's your name? Where you calling from?
Hi there. I go by the handle Beware Mouse online. I've been a long-time watcher of you. I think I bumped into you when I was in St. Louis 7 years ago or something. I had something to do with the Ferguson thing. I have a couple of questions for you. Every time I think of you, I think of the Michelin Man of jurisdiction. Just a walking, huge, monstrous tire contraption. But I know it. But it's meant to be a compliment. But that is the image I keep getting of you. You're made of rubber, man.
I'm trying to think about St. Louis.
Two questions.
I've never. Real quick. I've never actually been to St. Louis. I've taken a call from a number of people that were involved with some case in St. Louis, but I've never actually been to St. Louis.
No, let me correct that. I think I was one of those callers at the time. You had lent some insight to the jurisdiction. We had a problem with the fact that St. Louis County is separate from St. Louis Court. And there was something dating back to the 1400s, or I don't know. But anyway, you had a clue on that, and we followed up with you. I was part of the research team that was down there doing the hard book copy, and we got the 5-second rule overturned.
Oh, okay.
Okay, you helped on that because you lent us some of your specific narrow knowledge on the jurisdiction. That was also the reason for my call today. First of all, normally when you approach the jurisdiction, you normally don't approach faults within the calling you to the court. You're normally, why are you being called? And if they have an affidavit, what does that matter? Standalone position. But do you have advice when you find severe deficiencies in bringing you to court? Example, you have a warrant, but no affidavit accompanying the warrant. That's an invalid warrant. So how would you present that? And the other question I have is, the half of challenging the jurisdiction is great, but if you actually had to follow through in their forums, would that next step after challenging that jurisdiction be removal to federal court?
Oh, okay. We got a lot to unpack here. Removal to Fed. Removal to federal court usually only works if you're the IRS or a federal agency. A severe deficiency. Well, first of all, we have to look at the context of the warrant. If it's a bench warrant, and let's say it's because somebody hasn't appeared, then the judge doesn't need a warrant for the arrest there. It's different. So if a police officer comes in and wants to swear out a warrant for the arrest of somebody, that has to be by affidavit. So it depends on who's it, why the warrant is being issued.
Okay, can I go back one then? If you're giving an actual bench warrant without an affidavit, then there had to have been previous action in that case. The question, I guess I have to ask the right question to get the right answer. The question is, can a court be moved at all without an affidavit? Can you be brought to court at all without an affidavit?
Yeah, you can. It can be. For example, I'll get to the government in just a moment. I could file a claim against you, and well, let's not use that.
But that's an affidavit, isn't it?
No, I can file a complaint.
That would require your affidavit and your statement.
No,
let's say we have a traffic ticket. Okay, it's a boxed out traffic ticket.
Okay.
So therefore, all fields are separate from all others, the same way it would be of notary. They try to bring me to court, okay, and then raise the ticket level or the severity level from what would normally be ordinary traffic court up to a county court level. And then I stand in front of the judge. I have a work report, not an affidavit, which they're claiming to be the police report. It's a work report. It's not an affidavit. There's no signature or verification of oath, okay, that is an affidavit. Under these circumstances, how can the court be moved without an affidavit verifying the police report?
Well, they do consider you don't need a technical affidavit for, say, a traffic ticket. The ticket is signed and certified. It's not necessarily an affidavit, but that certainly it qualifies legally to at least give the judge presumptive jurisdiction to have you appear.
Okay. So basically it's a presumption, but without the affidavit, who are you answering to? And hasn't all your rights with specifying the fact that you have a right to your accuser? Which are the 5 officers or your accusers that combined a report, which is none of them an affidavit, meaning that there is no valid action that the court can take. And in addition to that, without an affidavit, how can they ask for remedy? How can jail time be remedied?
Well, then I don't know of any situation that has been upheld where just a police report was filed and they were able to get a warrant without an affidavit, or the court ordered someone to appear just off of a police report. I don't think to something like that, even a diehard would have to say, well, yeah, that's kind of, you need an actual complaint. I think to get it started, under their laws, again, I don't agree with this. I think it's grossly unfair, but legally anyway, they file their traffic ticket, and that's what it does. If depending on where you are, like California says, it has to be for the court to get jurisdiction over a traffic ticket proceeding. The complaint has to be it has to be a verified complaint. But then they went and they just said, well, the officer signing it is sufficient because it's under oath. Okay, so that's what gets it started.
David. You're breaking up.
Well, I was just saying that the ticket, like I say, in California is considered verified. So their laws say that they have to have a verified complaint. And a lot of tickets, and I know people have done this, a lot of tickets have been tossed out. I know someone got like 10. I was like, you probably should just stop doing what you're doing and not getting these tickets. But you do that if you're an activist. And they wound up having a an appellate court case that upheld a prosecutor's argument, a state attorney's argument, that the ticket, since it's under oath and it's certified, counts as a verified complaint. Where it used to be before, if you said there was no verified complaint, the judge would throw it out. But they don't do that anymore, and I haven't done that in a long time.
Well, technically, though, technically they're supposed to do it. It's a matter of new practice overriding actual law, isn't it?
Well, no. If they're going to, if the appellate court is going to, a lot of background noise. If the appellate court is going to hold that the ticket, being that it is signed by the cop under some kind of penalty of perjury, or that is some kind of certification, if they're going to hold that is in fact under their law a verified complaint, then legally that is a verified complaint until you can have a better counter argument and show that that court was actually wrong.
So basically it's taken at face value until it's challenged, and you actually physically have to challenge each piece as it goes. Then
I challenge it by demur.
I think I like your original idea. Just say, the heck with this court. Why are you bothering me at all? Rather than trying to play their game at all.
Well, but that's my position is not to ignore. My position is to file a demur under the government code, section 1001, I think it is, and challenge the factual basis, the factual sufficiency that there aren't sufficient facts to set forth a valid public offense. That's my chosen way, and I've done that quite a long time now. I don't just tell people just blow it off. Quite the opposite, especially when you're dealing with the IRS. If you blow it off, they're just going to escalate, and the more it escalates, the worse it's going to be. And in fact, I've been in situations where, I've worked with people where they did blow things off, and a judge looks at them dead in the eye and says, "Why didn't you respond and raise these arguments 6 months ago when you had every opportunity to?"
Right.
And
I've seen that.
Yeah, it makes us look bad. So too. I am of the position. My position is I want this over as painlessly and as quickly as possible, and so I'm going to hit them right at the foundation of their claim. They believe that the basis of their jurisdiction is that their constitution applies because I'm physically in Arizona. I know that's what their claim is. When I ask them, they'll verify it, and I challenge that because I know that it can't be proven. And the best they could do, again, not somebody on the internet, but actual state actors, the Supreme Court Chief Justice in Arizona, Scott Bales, and Bill Montgomery, at the time, the county attorney, the official position was, if you're physically in Arizona, the laws apply because we put other people in prison. That's their position. I'm not making it up. I actually have the document on the website that Jerry Cobb from Bill Montgomery's office provided. That's the official position of the Maricopa County's office. It doesn't matter. I don't give a damn if someone on the internet says that that's wrong. That's the official position of the
that's established practice.
Yes,
that's established practice.
Right. That's what they're actually.
It's as though you have put handcuffs on the moment that you cross the state border.
Well, in a sense, it's a lot worse when you cross over to California.
By their permission.
Well, it's a lot worse when you cross over to Colorado and you go into California. You got a lot more shackles on you. I mean, if you were to get on a motorcycle without a helmet with an AR-15 on your back, you're perfectly legal in Arizona. But the moment you cross that river, you got some problems. You probably want to getting shot at, if you're on I-10, you're going to get shot at the at that way station. But I've always, and this is for new people, I am always for addressing it as soon as possible, and I want to destroy the foundational claim that they're making, not blow it off or argue these other things.
I had a recent event where I was charged with obstruction. There was no affidavit. There's work orders and work reports, but no affidavit. They pointed to the ticket. I pointed to the boxing of a notary public. This is incomplete. This is not even a legal document according to legal documents.
Well,
okay. Am I guilty of my name? Am I guilty of some number? And what am I reading here? I'm certainly not guilty of a single word. It doesn't tell whether I committed it or whether I assisted it or whether I was obstructed because I had signed it 18 USC 1512 as my signature. They obstructed me. I didn't obstruct anybody.
Why would you sign
And
the
it
ticket?
sat there.
Wait, all right, hold on a second.
Well,
Why would you sign the ticket with that statute? What is that statute? With a federal statute? Well, because we're actually supposed to get
federal
to
statute is a witness, your witness protection. It's also 1512 is also your press investigation, your power of a civil investigation as a member of the press, and was originally used most notably with the Washington Post concerning Nixon.
Okay, that to me, I don't have the time to go through the weeds of that one.
Well, that's your press. That's your federal press shield. Whether they've adopted that in state law or not, that's your federal press shield. Being an investigator, you can come against a lot of intimidation, stuff like that, looking for a FOIA request. It's the actual criminal charge for that obstruction of that investigation.
Okay.
It also specifies that if they arrest you in the course of that investigation, that is also an illegal act, and it specifies that.
I'd have to look into it. It doesn't seem to make any sense at all.
Again, it's 18 USC 1512.
Okay.
I do a show based on that quite often.
Okay, I will have to.
I only have 2,000 subscribers, but I dig into the law. And again, thank you very much for your time today.
Well, that's no problem. I just want to address your other question, though. You were asking about removal to federal court. So you're talking. So get specific with me so I can address this. You're talking about taking what kind of cases or proceedings in state court are you removing to the federal court?
It would be a criminal case where I show that they had to violate a civil law prior to the fault. In other words, it's filed its original first fault.
Wait.
They narrowed the charges to a single event over a course of event, trying to get a guilty plea, which would actually engage a law called or a finding called Heck versus Humphrey. You can be arrested for shooting someone and murdering them. They can beat the shit out of you. It turns out that the only thing you were guilty is spitting on the sidewalk. As long as they find you guilty, you can't sue them.
Wait, but
and that's Heck versus Humphrey.
What kind of criminal case from the state court are you removing to the federal court?
Pattern of behavior, systematic systematic something of a official procedure, obstruction of official procedure, and those are all the charges that they were guilty of prior to even the first arrest.
What charges? What criminal?
We're trying to consolidate five years.
Hold on a second there. I gotta mute you up for just a second because I'm running out of time and I want to get this through. What state charges are they charging you with that you would then remove to federal court?
False charge of threatening a judge.
Okay.
That a wish and a prayer to not a federal judge, I'm sorry, to a local judge, a wish and a prayer of the results of what's going on is basically what they took as a credible threat.
Okay, all right. Now,
they converted a religious act of retribution into a credible threat.
Okay, all right.
In order to do that, they had to determine one that there was a God.
I don't need that yet. I don't need that information. Okay, so you're telling me you filed successfully a removal to the federal district court, a state charge of threatening a local judge. That's what you did.
We have not done that. That's the reason why I was calling you, is because we're researching the possibility of doing that.
Good. Well, I'll point out that I don't think you can get anywhere doing that. I'm glad you're calling about that instead of just doing it or telling somebody else to do that. To do a removal to federal court, the federal court has to have concurrent jurisdiction over the state charge or what's in the state court. So just to throw it out, you can do a RICO complaint in state court. You could do that. you can then, because it's got concurrent jurisdiction with the district court, it can be removed to the district court if you have reason to do that. But the federal district court must have concurrent jurisdiction. I don't think you're going to be able to find, and I don't think it exists, and maybe I'm wrong.
Okay, what if I use the argument? What if I use the argument that the state has no duty within to enforce your civil rights, that the only people that have that would be the federal government in the federal court and civil court, and that the first fault is that the value of the first crime committed here was a civil violation? Do you think that would fly?
No, you have to be able to show that the state court has concurrent jurisdiction over the charge as the federal court. So over the cause of action. So whether it's civil or criminal, you have to show that the federal court has concurrent jurisdiction, not exclusive jurisdiction, because then you could just get it dismissed for a lack of jurisdiction.
That's what I thought. Okay, the concurrent jurisdiction is what's throwing me off.
Yeah.
Now,
So
exclusive, I understand, because that would be based on the rights, but that is after that the criminal charge, and they'll allow that in order to continue at the lower level.
yeah,
So I've seen that happen. I've seen people try to move it, but even with a habeas corpus, they use the same excuse. Well, this case ain't done yet. It sounds like you're just trying to get out of, and then they'll send it back to you, ignoring your habeas corpus as well.
Well, if you're not actually physically in custody, they don't have to take the habeas corpus, because that's been narrowly construed to mean that any restriction of your liberty is narrowly construed to mean jail or physical state custody. So that's that. So hopefully we saved you some trouble, and that you're not going to go ahead and try to do a removal. The only time I've seen, the most I've seen with the federal removal stuff is if you file against a federal agency like the IRS into the state court for a violation of state law. Then they walk in and they file a removal. So the first time this happened to me, I'm thinking, hey, this is actually pretty cool. Now we can argue that the federal court has jurisdiction, and they can't argue it doesn't, because they did the removal. And the only way that they could do a removal is if the federal court has concurrent jurisdiction. So I'm thinking, great. This is pretty cool. Thanks a lot, guys. Well, the federal court said, well, immunity denies the federal court the jurisdiction. Yeah, but then you can't remove it in the first place. They didn't let it go. So I do appreciate the call, and I hope we were able to save you some trouble there. So we don't do that removal.
You bet. No, I appreciate it. Listen, go ahead and write down my number separately. There's a couple of things I'd like to talk to you, possibly about syndicating your show as well.
Yeah, you can email me or Skype me.
Or at least.
Okay.
Well, it'd be a shortcut if you wrote it down. All right. Thank you very much for your time, though.
Yeah, I appreciate the call. Thank you.
Appreciate the call.
I think
you're awesome.
Thank you. Well, we're out of time, so I'm going to exit out of that there. I'm glad at least potentially some, a real waste of time and money was averted. We do not do a federal, and if you think the federal courts, especially in tax cases, if you're thinking you're going to get a better shake out of them as opposed to the local guys, I've not, especially in tax cases, I've not seen that. But the state court and the federal court must have concurrent jurisdiction. Now, obviously, if the federal court has exclusive jurisdiction over it, then you don't have to bother with that, because the state court, you presumably would be able to show that they don't have jurisdiction because only the federal court does. So the removal, there's a lot of things, and I understand the frustration to try to get these people to stop, but our legal remedies are not nearly as expansive as some people may lead you to believe. So somebody's saying something here I wanted to respond to. Mark Stevens, this is not the first time an IRS agent said they don't have to prove anything. Correct. Yes, that's true. And that's why I mentioned that we had Agent Marconi in California, and his supervisor Jones, I think it was Bob Jones. And Bob Jones was actually the one that added to it and said that the IRS, we don't need evidence. We don't have evidence, and we don't need evidence. Now, as I mentioned at the beginning of the show, by their own rules, this is wrong. by their own rules, that is dead wrong. You got Helving versus Taylor, Commissioner versus Internal Revenue, Burkhardt versus Janus, where they talk about a naked assessment. The foundational claims by the IRS or any agency, but they're dealing specifically with the IRS there, is that if the foundational claims or assumptions and are not based on facts, then it's called a naked assessment and is invalid. No presumption of correctness is created. You do not get a presumption of correctness no matter who you are. Whether you're me, someone on the internet, or a state actor, an IRS agent. Under their rules, their sacred writ, you do not get a presumption of correctness unless it's based on fact. If it's an assumption, like I've gotten them to admit so many times, it doesn't. No rebuttable presumption is created on an assumption. And you cannot prove any proposition beyond a reasonable doubt if you start with an assumption. I know, groundbreaking stuff there. But most people, especially in the legal field, it is revolutionary. Well, you got to accept this. You can't look behind the curtain. You have to accept it. This is your starting point. You have to start with the law. You can't go and challenge their assertion that applies to you other than looking at the text of the statute. I disagree. And we got another success story that I will get posted. So now I got a few extra that I can put in there. So anyway, we are out of time. I will be a little bit delayed because I don't have the good audio from my end. I apologize for that, but I'll clean up the stream audio. I'll get that posted at markstevens.net. And if you are being attacked by a bureaucrat, get a copy of Government Indicted. Listen to the shows. Look at the articles. Look at the evidence of people that have gone before you, and like Lestat this week, who got a ticket kicked out by the prosecution. Not him. The prosecution did it in the interest of justice because he didn't have any damn evidence. He couldn't make his case beyond a reasonable doubt, so you kick it out. They did the right thing. But you can see all the evidence there at markstevens.net. I will be live on the Wednesday. I'll be live on the Saturday show again, and we'll hopefully have a little more time, and I'll get this damn thing straightened out so I don't have to lose my recording and my good recording. So until then, salud.